My lady, my lords, at the end of yesterday, I dealt with what the appellants say general and indiscriminate means, and I now need to turn to why the Divisional Court say that's wrong. The substance of the Divisional Court's reasoning is in its 2018 judgment. That's in the core volume at tab 25, and the relevant part is at page 878.
Tabs might be different. It just
29.
29.
29.
Yes, I'm sorry I've given you a bad reference. It is tab 29. It is hopefully still page.
Yeah.
It is 878. There are a number of reasons which the Divisional Court gives, and the analysis starts at paragraph 127. The first point that's made is that the 2016 Act, which is the Data Retention and Investigatory Powers Act, under which retention of communications data is possible, is very different from the Swedish legislation. That Act doesn't contain a blanket requirement requiring the general retention of communications data.
Mr. Jeffy, you knew where you were going before we came in. I didn't. I'm still trying to catch up your reference.
I do apologise. It's tab 29 of the core bundle.
Got it.
And it's the Divisional Court's 2018 judgment.
Page?
Page 878.
I'm on the right page.
Paragraph 127.
Thank you very much.
I'm grateful. I'm sorry I took that too quickly.
That's okay.
So the first distinction which the Divisional Court identifies is the domestic legislative scheme doesn't contain a blanket requirement, it contains a discretion. The difficulty with that argument is that exactly the same can be said about the Telecommunications Act 1984, which was dealt with by the Court of Justice in Privacy International. That was also a discretionary scheme.
But I'm not following that at enough detail to understand what you mean. This says the Act does not contain a blanket requirement. And what are you saying? What section of what Act does contain a blanket requirement, and therefore this is wrong?
What the Divisional Court is doing is it's saying that, well, other legislation that the Court of Justice has considered in the past contains blanket requirements to retain everyone's data as a matter of mandatory duty.
Yeah.
And the Divisional Court is then saying, well, this scheme that it was considering, and there it was the data retention provisions in the Investigatory Powers Act, is different. And the reason why the Divisional Court says it's different is that there is no mandatory duty in the legislation to retain data. Instead, there is a power or a discretion for the Secretary of State to make a decision that data ought to be retained. And therefore, that tends to indicate that the power is not a general and indiscriminate one. I think that's the
Okay, and the
shape of the argument.
telecommunications, that's the same words, no mandatory requirements, and that was enough.
Yes.
Right, okay, I'm with you now.
I mean,
And the context is a discussion of Watson, is it?
the context is exactly as a discussion of Watson.
I think perhaps you've left in a little, might be helpful to go back and just have a look at the reason why the court came to that conclusion if one looks at paragraph 121.
Yes, that's right, Mary.
They're discussing there your reliance on various passages from Watson. Is that right?
Yes, that's right.
And that's the context of this later discussion which you've taken us to.
That's correct.
You have to remember that you've been dealing with this case for 5 years.
No, I do apologise. I'll take it a little more slowly.
Yes.
So, what the Divisional Court was considering there is it was considering parts 3 and 4 of the Investigatory Powers Act. Part 3 being the power to access communications data, and Part 4 being the power to retain it, which, as my Lord Justice Lewis said yesterday, is perhaps the wrong way round. And in the Watson case, which was joined with a Swedish case called Kelly 2, the general and indiscriminate issue was considered by the Court of Justice only in the Swedish reference. And the Swedish reference involved a very simple piece of legislation, which was a cut and paste of the European Data Retention Directive. And the European Data Retention Directive provided for mandatory retention. It simply said to all the communications providers in Sweden, thou shalt retain this communications data for this period as a blanket legal requirement imposed on them all. And the Court of Justice said that is a general and indiscriminate requirement. What the Divisional Court is saying here is the Divisional Court is saying, well, this scheme under the Investigatory Powers Act is different.
From the Swedish legislation?
From the Swedish legislation.
Well, it also says in paragraph 126, it's particularly note, as you accepted, the requirements of the Swedish legislation were not qualified by either a necessity test or a proportionality test.
Yes, that's
So
right.
that's part of the
Yes, that's
important context as well, isn't it?
That's right. And the court found, and that's one of the later reasons, there are a series of reasons, and reason number 2, as my lady points out to me in paragraph 128, is the inclusion of a necessity and proportionality requirement in the Investigatory Powers Act. So that is then picked up and relied on by the Divisional Court against the appellant.
What I'm missing at the moment is this. This legislation is different from the Swedish legislation. So what's the relevance of the Telecommunications Act 1994 to the different act, and which they didn't actually consider? It might well have said something about it, but how is that helping me is the bit that's missing from the jigsaw, if you follow me?
The reason I say that's the missing piece in the jigsaw is that the Divisional Court in 2018 did not have the benefit of the Court of Justice's judgment in Privacy International, which came after that. And that judgment considered a scheme which was discretionary in nature, the Telecommunications Act 1984. And nevertheless, the Court of Justice found that it was a general and indiscriminate scheme.
Right.
And so my submission on the first reason given by the Divisional Court at 127 is that that argument is no longer a sound one.
Right, now I've got it. Sorry, yeah.
Do we look at all these factors singly or cumulatively?
The Divisional Court, I think, adopted a overall analysis. So it looked at a series of factors and concluded on the basis of all of those factors that the scheme was not general and indiscriminate. So I think I need to address them all. But I'll take them in turn if I may. But the first one and the most important distinction which is identified is a distinction which we say can no longer stand following Privacy International. And the reason for that is that the Court of Justice in Privacy International didn't think that the fact that there was a discretionary decision changed the substantive nature of the scheme under consideration. It was a question of procedure rather than substance. It could still be a general and indiscriminate scheme, even if the legal arrangements required a discretionary decision to be taken, for example, by the Secretary of State. That didn't change the nature. Then paragraph 128 is the second reason. And the second reason that's given is that the Secretary of State may only exercise the power if she considers it both necessary and proportionate for one of the specific purposes. Now that is, of course, a distinction with the Swedish scheme that was considered in Watson and Tele 2, which was simply mandatory. There was no public official that had to take a decision. However, we say that distinction no longer holds good again after Privacy International. And the reason for that is that in Privacy International, the Court of Justice was considering the Telecommunications Act, which had an express requirement of proportionality. It didn't have an express requirement of necessity, but I'm not sure that makes any practical difference.
Why does it make no difference?
Well, the purpose of the addition of the requirement of proportionality, and it was added into the Telecommunications Act in 2000 by RIPA, when the Human Rights Act came into force, must have been to attempt to comply with the Human Rights Act requirements of necessity and proportionality. It's very, very difficult to obviously that it wouldn't include that the concept of
It's a
proportionality.
separate limiting feature.
It is a limiting feature. I suspect, though, that the intention must have been that when we speak of proportionality, an element of proportionality is a requirement that the measure is in fact necessary.
Usually the other way around. Proportionality is an element of necessity. Legitimate aim and proportionate.
Yes, all right. I take my Lord's point, but I suggest it's not a significant distinguishing factor because, again, there was a stage in the Telecommunications Act requiring a decision to be taken as to proportionality. The third reason is that the Divisional Court says that, well, although there is a power in the Investigatory Powers Act in Part 4 to require the retention of all data, that can't be read in isolation and taken out of context. The claimant's submission overlooks the statutory requirement to satisfy necessity and proportionality tests. Difficult to conceive, it says, how a retention notice drafted so as to encompass all communications data in the UK could satisfy those tests. Well, we do say it isn't actually that difficult to see how it would be necessary and proportionate to just draft a notice to collect all communications data in the United Kingdom, because that is, in practice, a key purpose of the regime, to ensure that the data is retained so that it can be made available in the event that a justified request is made for it. So the logic of Part 4 of the Investigatory Powers Act is that all major or substantial communications providers can be, and probably ought to be, issued with a notice to retain their communications data. Now, no doubt there may be some tiny provider in the outer reaches of the Highlands, perhaps, where it's not truly not proportionate to require them to engage at a cost. But one finds it difficult to imagine why all of the major providers who provide the vast majority of telecommunication services in the United Kingdom are not going to be issued with such a notice. And in fact, all of those providers must have been issued with a notice, because in every Crown Court up and down the country every day, extensive communications data from every telecommunications provider, BT, O2, Virgin, Vodafone, doesn't matter, is adduced in open court as critical evidence advanced by the prosecution. So those retention notices must have been issued against all the major providers to enable those providers to provide that information under Part 3 when it's requested to do so.
That assumes that if not subject to a notice, all the providers would destroy or lose, or whatever the right term is, everything immediately.
Well, under Article 5 of the e-privacy directive that we looked at yesterday, that is the obligation on the providers. Once they no longer need the data for their own business purposes, they are required to destroy it. And that is why these retention provisions exist, because it is onerous and expensive to retain all of this data in accessible and readable form. And the reality is that something close to a comprehensive suite of retention notices is the only logical use for these powers. Otherwise, you're going to be, if you decide to collect the data of one mobile provider but not another, that means that in many criminal cases, you simply won't have the location data and the call data that's critical for deciding whether or not someone has a good alibi or where they were at a particular time. So when the Divisional Court say that they don't understand how it could be necessary and proportionate to collect all communications data, that's not practically correct in terms of how these schemes operate. Paragraph 130 does identify a distinction that we accept exists. So under all of the Investigatory Powers Act schemes, there are time limits. Under the scheme that was considered in Privacy International, under the Telecommunications Act, the national security notice had no time limit. What we say about that is that the existence of a time limit doesn't affect whether or not the retention is general and indiscriminate during the period of operation of the authorisation. It may be general and indiscriminate only for a period, but nonetheless during that period.
Are you saying anything more than that a notice which requires retention of all data is necessarily indiscriminate?
Yes.
That's your. I mean, that's all you're saying, isn't it?
And we're saying
You say privacy supports you.
we do. We say that that is what the Court of Justice case law has always indicated. But if there is doubt about that, we say that doubt is confirmed by Privacy International.
But if I'm sorry to take up your time, but if the purpose, the underlying purpose, whether it's the statutory purpose, is to ensure that for reasons of national security or whatever, you capture the relevant data, even though you don't know where it is, you've got to ask people to keep everything. And then the question is, how do you limit it from there on? So what am I missing? What's wrong? I mean, you can give it the epithet indiscriminate, but it's necessary. So what's wrong?
We don't dispute that. I'm only at the stage of categorising these powers, and the Court of Justice then says that doesn't mean you can't have these powers, it doesn't mean you can't use these powers, but it does mean that there is a particular set of safeguards that are appropriate to them.
Okay.
And the reason why the Divisional Court says that those safeguards don't apply is because these powers are not, in the Divisional Court's view, general and indiscriminate.
So that's why you want the epithet.
Yes, that's why I'm sorry I'm labouring why we say it is. But my Lord puts a good point to me, because the purpose, I've given the example of a simple criminal investigation using communications data, but the justification for the bulk powers, and it's a justification that was put in the public domain by Lord Anderson in his question of trust report, is he said, for example, the bulk acquisition power, which is give the agencies all of the communications data for them to hold themselves rather than being kept by Vodafone, so they can process it rapidly and analyse it rapidly. Lord Anderson said that power had proven very useful in urgent counter-terrorism investigations because it allowed potential suspects to be identified at pace and to be tracked at pace. Now, in practice, the agencies do not know which mobile phone network a potential suspect might use, so it has to serve a notice on all of them, because otherwise the power will be ineffective in practice. To use the language of the Investigatory Powers Tribunal, these powers necessitate collecting the haystack, because unless you have the whole haystack, you're not going to be able to find the needle. Now, that doesn't mean the powers are wrong, it doesn't mean they can't exist, but that is the true nature of the power which Parliament has granted. And that affects, we say, the safeguards that we apply. Then at paragraph 131, the Divisional Court refers to various factors, including a duty of consultation. We simply say that such a duty of consultation also exists in the Telecommunications Act 1984, so that doesn't distinguish Privacy International. Paragraph 132, it's then said that a retention notice must be approved by a judicial commissioner. We respectfully agree that that's different from the Telecommunications Act, but that doesn't stop a notice from being general and indiscriminate, because that's just an epithet or a description of the type of power that's being exercised. It may be a general and indiscriminate power that is being authorised by a judicial commissioner, but the nature of it doesn't change. Then paragraph 133 deals with the test applied by the judicial commissioner. And then 134 is the seventh and final point, that there are arrangements for the referral of a notice for further consideration and an advisory panel called the Technical Advisory Board. Again, those are no doubt valuable safeguards, but it doesn't change the essential nature of the retention taking place.
This all predates Privacy International, as you've said. And when was that decision? Was that 2020?
Privacy International was, I'll give you the exact date.
My memory serves me correctly.
It was handed down on the same date as La Quadrature, which was October the 6th, 2020.
22, so that predated, and it was considered in Big Brother Watch, wasn't it?
It was.
International.
So what we say is that these schemes, the bulk schemes, are general and indiscriminate in nature. That simply means that there's a particular set of safeguards which apply to them. Some of the safeguards are actually removed. So certain safeguards that apply in cases of acquisition for criminal investigations are removed, but a different set of safeguards are applicable. What the safeguards ought to be are, we say, set out in the Court of Justice's decision in La Quadrature, and that's the judgment that was handed down on the same day as Privacy International. That is in tab 18 of the authorities, at page 649. There were a whole series of issues considered in La Quadrature, as is clear from the length of the judgment. But one of the schemes that was considered in La Quadrature was a French national security scheme, which required communications providers to analyse all of their communications data themselves. So they were given a series of secret instructions and access to sensitive equipment by the French authorities, and they were required to do the bulk analysis on their communications data, and it was done in cooperation with the providers. So rather than collecting the data into the French security services and then doing the processing, they issued sensitive instructions to the communications companies for them to do the processing, no doubt with various precautions to ensure the security of the information. That scheme is dealt with at page 764, paragraph 172. And paragraph 172 explains that there is a screening of all the traffic and location data retained, which is carried out by those providers at the request of the competent national, the French authorities, applying parameters set by those authorities. And such automated analysis involves, the court finds, general and indiscriminate processing, unsurprisingly.
So there's no selection at the start. They just tell the French ones, collect everything, and then they say, and look for the following.
And look for the following. Maybe obviously the details are no doubt sensitive, but presumably the communications companies are told to search for particular selectors or groups of selectors or particular patterns of behaviour online and report the findings back to the French authorities.
Yeah.
So it's a similar type of activity as is conducted under the bulk powers, the difference being that it's conducted by the communications companies following instructions from the French authorities rather than being done by the French intelligence agencies themselves.
But it's all data seized and all data searched. Not all data seized, some data searched.
It seems to be all data seized and all data searched.
Yeah, so that's different from what we've got with bulk,
It is.
isn't it? Yeah.
Exactly, and it's different from Privacy International in that respect. So I can't rely on this case for the meaning of general and indiscriminate.
Yeah.
Then at paragraph 178 on page 766, the court concludes that such activities, and this is the last three lines, may be considered to be justified. So it's not that you can't do it, it's the conditions that need to be applied. And then there are a series of requirements which are identified. The first one is in paragraph 181.
And this is applying to a different factual situation to the one that arose in Privacy International.
It is.
Yep.
In Privacy International, the Court of Justice simply found the arrangement was unlawful in its entirety and said that it wasn't permissible under EU law. But there are, I'm not saying that such an arrangement could never be permissible, because in a case handed down on the same day, some safeguards were identified that would make it potentially lawful, something similar potentially lawful. So it would be unrealistic for the appellants to submit that it cannot be done when the two cases are read together. The logical reading is that it can be done, subject to the safeguards that are identified. And Privacy International, of course, extensively cross-refers to this judgment in La Quadrature as setting out an application of principles. So the criteria and the safeguards that are identified are, first of all, at 181, automated analysis must be carried out for national security purposes rather than other purposes, and there is a requirement of non-discrimination. Then in paragraph 182, there's a requirement that before action is taken against anyone based on the analysis, there's review by a human.
Sorry, what did you say 181 actually said? I thought you said you couldn't have premises about ethnicity. Looking at it, it seems to be saying the opposite. Just to make sure I've not misunderstood what you said.
What 181 says is that this activity can be carried out, but the automated analysis carried out on the basis of models and criteria founded on the premise of various categories such as racial and ethnic origin could in themselves be relevant to prevent terrorism, would infringe the rights guaranteed in Articles 7 and 8, read in conjunction with Article 21, and then the conclusion. Therefore, pre-established models and criteria for the purposes of an automated analysis that has its objective the prevention of terrorist activities that constitute a serious threat to national security cannot be based on that sensitive data in isolation.
Yes, you can't just racially profile, but it may be a factor, seems to be what they say.
That is right.
Okay, yeah.
That is what they say. And our submission is simply that these requirements are not present, either in a legislative measure or in the domestic codes of practice. These are not particularly onerous requirements, it must be said. But if this type of activity is going to be conducted, bearing in mind the potential dangers that it imposes, we say that those safeguards need to be in place.
This is stage 2, it's not the collection, this is the analysis, isn't it?
Yes.
Well, what the Court of Justice has always done is it's said that collection and analysis can't always be split out, because in a bulk regime, as was explained in Big Brother Watch, the initial act of collecting or obtaining a large volume of information is an interference with privacy, but is perhaps not the most serious interference.
But there's no way in which you complained about being general collection of data. By definition, it's not based on ethnicity at the stage of collection.
It's the analysis.
Yes, it's the analysis.
That's right.
So I don't see how you need, at the moment, to have something saying, when you're collecting data generally, don't base it only on racial profiling, because that's the opposite of what you're doing at the collection stage, and that's what you're partly complaining about. Yes. Anyway, I've got the point now.
What the court is dealing with there is it's dealing with the analysis stage.
Yeah.
And what the court is saying is that the collection, the bulk activity, is not lawful unless you have proper safeguards for analysis, which is the same type of reasoning as one sees in Big Brother Watch. The bulk activity can only be justified by appropriate safeguards downstream when it comes to the question of analysis. There's one final point on ground 1 of the EU law, which is that the respondents also say that Part 7 of the Investigatory Powers Act, covering bulk personal data sets, is not within the scope of EU law at all. And so none of these issues or arguments can apply to bulk personal data sets. The appellant agrees with that up to a point, and the point of divergence is where the bulk personal data set has been obtained using compulsory powers against a telecoms provider. And it is that instruction or order to a private company that provides telecom services that engages EU law. And so some bulk personal data sets will be outside the scope of EU law if they are obtained, for example, by the agencies without the use of any mandatory power. So it's possible to imagine a situation in which an airline might voluntarily provide a copy of its flight manifests to the Security and Intelligence Services. And there is a Data Protection Act statutory gateway that allows individuals and companies to provide information voluntarily to the agencies. There, EU law would not be engaged because there is no compulsory power being used against a private individual or company. In contrast, where the powers under the Act are being used to get the data set in the first place, we say EU law is engaged. And that is the dividing line that the Court of Justice has also adopted.
But Part 7 doesn't concern the collection, does it? That would be a challenge to the other acts under which the different bodies get the information. I thought Part 7 was voted on, so I may have got it wrong.
That's right. Part 7 does not contain any power to acquire. Part 7 simply contains the safeguards that are to be applied where something has been categorised as a bulk personal data set. And that is exactly the same as, for example, the scheme that was considered in Watson, by analogy. So in Watson, there was a law relating to data retention, the Data Retention and Investigatory Powers Act. That was the compulsory power to require retention. And then there were separate powers permitting the police and the agencies and local authorities and so on to obtain communications data and then to analyse it. And what was wrong, the Court of Justice found in Watson, was that the scheme for obtaining the data and analysing it didn't require prior independent authorisation. And the way the Court of Justice has always approached all of these cases is to look not just at the power of retention, but also to look at what powers exist governing the analysis of the data. And the cases here where we say EU law is going to be engaged are those cases where compulsory powers are used to obtain the data set, and then it's treated as a bulk personal data set. And there's an express provision in the Investigatory Powers Act to deal with those type of cases.
What if the respondents accept that, don't they? That it's, or maybe they don't.
I think they don't. Is our understanding. I'll be corrected in due course if we've misunderstood that. But we say that's the proper dividing line, and that's supported by two things. First of all, Section 225 of the Investigatory Powers Act. That's in the authorities at page 2874. The effect of Section 225 is to provide a regime for converting data that's been, as subsection 1 explains, obtained under a warrant or other authorisation given under this Act into a bulk personal data set.
I thought we weren't dealing with most of that. I thought most of what we were dealing with was things acquired by the intelligence service, not under a warrant authorisation given under this act. They've got other powers apparently and under other acts, and they've taken it, or they've seized it. And then if they want to keep it and search it, they've got to get an authorisation under Part 7. Is that right?
Yes.
Right.
It depends on, all that we are saying is that where the powers in the Investigatory Powers Act have been used to compulsorily obtain data and then under Section 225 convert it into a bulk personal data set, the safeguards, or absence of them, in the bulk personal data sets regime have to be considered as a matter of EU law.
Right. So where powers used under the 2016 Act to acquire and then converted to a bulk personal data thingamabob under 225,
yes,
that narrow section of activity is covered, but not where they don't use the power under the 2016 Act to get the data in the first place. Is that the case?
Now, there might be cases...
Is that right? Have I understood it?
That is correct.
Right, so it's that narrow bit.
It is a narrow point, and it's a narrow point in issue between the parties. There may be cases under separate statutory powers where information is obtained compulsorily that might engage EU law, but none of the parties have asked this court to deal with those.
No.
Not least because we're not sure what they might be, to be honest. But they could exist.
I mean, do we know if this has ever happened, or do we just don't know?
Yes, we're told in the witness statement of Miss Montgomery Potts that it has been used a total of, I think, 9 times in the last 2 years for which she gives data.
Okay.
She, I think, gives data for 2019 and 2020, and I think it was used a total of 9 times in those years. I'll give my lord the reference for that in a moment. Supplementary, page 234 for those figures. So, whilst it may be a secondary issue before the court, it's not a non-existent issue. And the second aspect that we rely on in support of that is what was said in Privacy International about when EU law is engaged.
I'm very sorry to slow you down, but before you go to I think of all the sections in this Act, which, speaking entirely for myself, I haven't read before this case, 225 is about as impenetrable as anything. Could you just put into words that I can understand what 225 is doing?
225 is, in very general terms, a regime for moving or for shifting the safeguards which apply from another part of the Investigatory Powers Act to the Part 7 bulk personal data sets regime. So let me give a very simplified example. It might be possible to apply for an equipment interference warrant against the computer systems of an airline that was declining to provide flight manifests voluntarily. In effect, to steal, to take a copy of those flight manifests for the security and intelligence services so they can see who's going on their planes. So that would be a warrant obtained by, signed by the Secretary of State, approved by a judicial commissioner, to obtain for the specific purpose on a rolling basis of getting that information.
What power would that be?
That would be a Part 5 warrant, for example.
Part 5 warrant, okay.
Because it would be thematic in nature. It would be quite specific.
But it would be interference with the equipment, and you attach the word thematic to mean it covers
an entire organisation. Or
a particular airline or something, yeah.
A particular airline or a group of airlines.
Air traffic, yeah, okay. Yeah.
Or airlines in a particular country that decline to cooperate, for example.
Yeah.
Then, under Section 225, the Secretary of State can take a decision to move that data into the bulk personal data sets regime and to treat that data that's been obtained under other powers as a bulk personal data set. And that might be quite sensible because the bulk personal data set regime may provide a good and sensible set of safeguards for handling that data, because it is, although you're obtaining it by equipment interference and maybe interception, it is a database, those flight manifests, and so handling them under the Part 7 regime may be a sensible set of safeguards to adopt. And so it enables moving the data from one legal regime to another. And so the way it works is that under subsection 3, the Secretary of State may give a direction that the intelligence service can retain the data, and under 3B they can examine the data, and that other provisions and other safeguards cease to apply to the bulk personal data set. You don't need to worry about the exact detail of what they are.
So just to remind us why we're discussing this, the only purpose of this part of the argument is to show that there's one set of personal data sets within the scope of EU law, those which the security forces have acquired under the 2016 Act, but where they've moved it to another Act. So if we accept that and we find that they're within EU law, is it then your submission that you're into general or indiscriminate data, or what's the consequence now that we're, on your analysis, within EU law for these subsets of data?
We say the consequence is the same, and if the data is general and indiscriminate, then the fairly limited safeguards in La Quadrature du Net should apply to them.
But why is it general and indiscriminate? Because you've just told us that it's a Part 5 warrant, for example, for an organisation such as an airline. It doesn't sound like the things you were saying were general and indiscriminate.
Well,
the other thing, I understand why you bring it into EU law, but then having got it there, what are you going to do with it?
Well, I agree with my Lord's point, and there may well be some cases in which Section 225 is used in a way which is not, in fact, general and indiscriminate. But the powers do extend to cases where there is general and indiscriminate obtaining of data.
225 doesn't tell you anything about whether the data is general or indiscriminate.
No,
it just tells you which safeguards you're going to use.
I absolutely agree with that, my Lord.
Oh,
right. You've just got a block of data which constitutes a bulk personal data set,
Yes.
and you want to shift it.
You want to shift it. All we're saying is that where that's done, the safeguards which apply to the data are within the scope of EU law.
If it's general and indiscriminate.
Well, even if it's not general and indiscriminate, it doesn't really matter. EU law imposes different safeguards on schemes that are general and indiscriminate and schemes that are not, and the safeguards may differ. But I'm just at the preliminary stage of arguing whether or not EU law applies. What the consequences of that may differ depending on the nature of the data set. But where the data has been obtained under a compulsory power, such as Part 5, or it could be Part 6, it would be possible we say EU law continues to apply.
The problem that I'm having with this argument is if it's acquired under Part 5 or Part 6, then whether it's general or indiscriminate will turn on an interpretation of Part 5 and 6 and all the other factors that we've looked at. When we get to Part 7, you haven't shown us anything yet that shows you can acquire data under Part 7, but you do tell us which safeguards will apply, because they might switch from one set of safeguards to another set of safeguards. But I can't see at the moment how the particular safeguards you use to whatever data set you're applying it to tells you whether the initial collection of that data was a collection that was general and indiscriminate. Yes. If you follow me.
Yeah, no, I'm not disagreeing with the point my Lord is making to me. Right. Then I accept that there may be some cases where data is held under Part 7 where the data is not on a proper analysis a general and indiscriminate data set. It will depend. One can imagine quite a narrow and targeted data set. But one has to remember about the definition of a bulk personal data set. It's a data set which contains personal data where the majority of the people whose data is on it are not and are unlikely to be of intelligence interest. So the nature we don't know the precise technical details, but the nature of those data sets is, we say, likely to be general and indiscriminate. And that is because you are seeking to collect data on everyone, even though most people on the data set will not and will never be of intelligence interest.
So if you've required data under another power and it's general indiscriminate, then you've got to have the right safeguards, and we've just got to bear in mind that we can't just look at the other safeguards, because there'll be a subset of cases where they'll have switched the safeguards.
Yes.
Is that it?
That's as far as the point goes, and I've said it's simply that the appellant has concerns that simply by using Section 225 and converting something into the Part 7 provisions, you don't remove the scope of EU law where it would otherwise apply. That's as far as the point goes.
Yeah.
I'm not going to take you back, given the time, to Privacy International, but yesterday we looked at paragraph 48 of Privacy International, where that test is set out, that where a compulsory power is being used against a private body, that is what engages EU law.
So we're assessing the adequacy of the safeguards under 225 against that data, which is general and discriminate, yeah.
Yeah.
Thanks. Sorry about that.
No, it's quite right. I mean, it's quite a picky little point, but nonetheless, it's a power which is being used in practice, and it's the position of the respondents that the mere fact that that power is being used removes the scope of EU law. It may still apply, depending on the circumstances. I'll move now, if I may, to EU Ground 2, which is about access to data for criminal law investigatory purposes. And as I've already said, in 2018, the Divisional Court decided that the Court of Justice in Watson required prior independent authorisation for criminal law access to communications data. And that led to the creation of OCTA in Section 60A of the Investigatory Powers Act and everything relating to that. And then in 2022, the Divisional Court took a further step, which is again not an issue between the parties, and said that where the intelligence agencies are acting purely for criminal law investigatory purposes, they have to comply with the same safeguard of prior independent authorisation. So a hypothetical example of that would be the intelligence agencies are looking into drug trafficking ring. Say they make a request under Part 3, or make an authorisation under Part 3 for communications data. That now has to go via OCTA unless it's urgent. That's the effect of the Divisional Court's judgment. But what the Divisional Court said is that that safeguard does not need to apply in an equivalent way to the use of bulk powers. The Divisional Court's conclusion is that Watson did not go so far as to require independent authorisation when data is selected for examination under bulk powers. Now, the consequence of that in practice is that the Divisional Court's 2022 judgment is unlikely to have much of a meaningful effect. And the reason for that is that as a result of the bulk acquisition communications data powers, the agencies are likely to have something approaching a comprehensive data set on their computers of communications data. And so if they wish to carry out exactly the same check or examination of communications data, they just don't need to use Part 3. they can simply examine the communications data which they've obtained under a bulk acquisition power, even if that is for purely criminal law investigatory purposes, and without the safeguard of prior independent authorisation. We say that position is illogical, and the Divisional Court's riposte is, well, the case law doesn't go that far, and there is no Court of Justice case law that applies the requirement of prior independent authorisation to bulk powers. And our response to that is that's wrong, and it was wrong both at the time the Divisional Court took its decision, and also we say that's been illustrated subsequently by later Court of Justice decisions. So the decision which existed at the time of the Divisional Court's analysis is a case called Opinion 115. Opinion 115 is in tab 16 of the authorities, starting at page 559. This is I'll be permitted the general term, it's a bulk case. It's about a draft treaty between the European Union and Canada requiring all airlines in the European Union to transmit airline passenger data to Canada before planes originating or in the European Union arrive in Canada. And the purpose of that was to allow Canada to do automatic analysis of the data to identify potential risks, both to airline security and also to their own national security of people arriving in Canada. So it's a national security treaty. It was a very lengthy treaty. There were lots of complex safeguards, and there were permissions for Canada to carry out automated analysis of the data for national security purposes. One of the concerns that the Court of Justice had was that Canada might not just do automated analysis before a passenger arrived, but they would then use the data for other purposes. For example, Canadian criminal investigations or the targeting or intelligence work on particular individuals later. And the Court of Justice's decision about that was not that it couldn't happen, but that if it did, it would require safeguards. And the safeguard they identified was the basic safeguard in Watson, that before there was to be individual work done on a particular target after the bulk analysis, before someone arrived and had done, it would need prior independent authorisation within Canada. That point is dealt with at page 605 of the judgment. Paragraph 201 and 202.
Just to help me, which section power are we talking about here? When you say bulk powers, what thing is it that you say requires judicial prior independent authorisation, which hasn't happened? Because the phrase bulk powers could mean a lot of things, really.
Here, what we say requires independent prior authorisation is the selection for examination of a particular individual's communications data, because that's the point at which a meaningful interference with privacy occurs. Once the mass of data, particular material relating to particular people, is chosen and selected and pulled out.
And which section governs that?
Under bulk acquisition.
Take part 6, chapter 1, if you like. Just give me the power, because I'll have to look at some stage at what happens.
Yes, it's in bulk for example, 6, chapter 1, it's section 152.
Right, that's okay, don't worry about it now.
Yes.
One can go back and read it, just so that I know the power rather than just a general phrase. Right, so you say selection for individual data, section 152, you've got to have prior authorisation and you don't have it.
Yes, that's right. Where it's being done for criminal law purposes, criminal investigatory purposes. As a result of la quadrature du net, that is not a requirement where the activity is being carried out for the purpose of national security. We previously argued that, and I don't pursue that submission, because la quadrature du net makes clear that's not the position. But what we do say is that where the agencies are acting for criminal law purposes and effectively doing the same interference using their bulk data as they could do in relation to an individual request under Part 3, that the same safeguards apply. And we say that's supported by paragraphs 201 and 202 of Opinion 115. 201 effectively says, yes, you can use this data because it has obvious potential benefits. But paragraph 202 explains that in order to ensure in practice the conditions set out in preceding paragraphs are fully respected, it's essential that the use of retained passenger data during the air passenger's stay in Canada should, as a general rule, except in cases of validly established urgency, be subject to prior review, either by a court or an independent administrative body. And then, for that proposition, Telly 2 and Watson is cited. So, Canada already has the data on a bulk basis held on its computers. But if the Canadian authorities, after someone's arrival, wish to then use it for a further purpose, then that needs to be, as a general rule, except in case of urgency, subject to prior independent review. And then over the page at paragraph 208, the Court of Justice reaches the same conclusion if Canada wishes to store the data after the passenger has left Canada. So if Canada decides it wishes to keep the data of particular people, then again it will need to get prior independent authorisation by a Canadian authority. So we say that that decision is strongly supportive of the submission which we make. The status of Opinion 115 is it was handed down before IP completion date, so subject to the regulations, it is still binding. Since then, there have been two further Court of Justice decisions, I'm afraid. One is called GD, and the other one's called SpaceNet, which confirm that line of case law. They're not binding on the court, but the court may, if it wishes, take them into account. The first one is GD, is at tab 20, page 822. This is a case in which was referred from the Irish courts, where the essence of the order for reference to the Court of Justice is, did you really mean what you said in la quadrature, and can we encourage you to go back on some of it a bit? And the Grand Chamber said no. The Grand Chamber also considered some additional issues at paragraph 64 on page 855, paragraph 64. And there the Court of Justice said, and they referred to the second question, that traffic and location data were legally the object of retention for the purpose of safeguarding national security. It doesn't have any bearing on the legality of their retention for the purpose of combating serious crime. So what the Court of Justice is saying is, yes, you may have retained data for the purposes of national security and done so legitimately, and maybe in those circumstances it doesn't require prior independent authorisation, but where you're retaining it for the purposes of a serious criminal investigation, our case law continues to apply. And then that analysis was repeated and then expanded in more detail in the SpaceNet case, which is tab 21, page 871. That's a German reference. And again, the Court of Justice confirmed La Quadrature du Net, but it also dealt with an argument that was advanced by the Danish government as intervener, and that's at page 901. And the Danish government put forward what we say is exactly the same argument as being advanced by the respondent. In this case, they argue that the competent national authority should be able to access, for the purpose of combating serious crime, traffic and location data that have been retained in a general indiscriminate way in accordance with La Quadrature in order to confront a serious threat to national security. So in other words, you've collected it for national security purposes, but you want to repurpose it or access it for the purposes of serious crime, and what should safeguards be there? And the Court of Justice says in paragraph 127 and 128 that its existing safeguards for criminal access will apply. And it cites the AG case and repeats its previous case law. And then there's an explanation of that over the page at paragraph 130. Which, if I can summarise it, just because you've got access to it exceptionally for national security purposes doesn't mean you can repurpose it and avoid the safeguards that apply to access for criminal law purposes. Really, this is a point about form and substance, and no more than that. The Court of Justice's case law has been that, yes, it may be possible to do a number of very exceptional things for national security purposes, but the safeguards that are required for criminal investigation are going to be different, and those safeguards can't properly be circumvented simply by using or reusing the data that you've got in for national security purposes, which is, we say, exactly the argument being advanced here by the respondents, and it was an argument which we say the Divisional Court wrongly accepted. That's ground 2, my lady, my lords. Ground 3 I can deal with very shortly. I've already made most of my submissions on it. It's that the breaches of the European Convention on Human Rights were also breaches of the Charter. And I've already shown the court the Charter, which indicates that its coverage is at least as broad as the Convention rights. It may go wider. But the Divisional Court did not conclude there had been any breach of retained EU law as a result of the admitted breaches of the Convention. We say the Divisional Court got that wrong. The quickest way of dealing with it is by reference to the 2022 judgment. That's in the core bundle at tab 31. And the Divisional Court's analysis starts on page 1031. At paragraph 150, the court summarises my submission, which the court then concludes at the end of paragraph 150 is rejected. The first thing that the court says in paragraph 151 is that Big Brother Watch is not directly binding on this court. The court has a duty to take it into account, and then what view the Court of Appeal will take is not a matter for us. Well, we submit that argument the extent it has any force, no longer applies, because of course the case is now in the Court of Appeal. Then, secondly, paragraph 152, the court analyses whether or not the Court of Justice would regard itself as being bound by Big Brother Watch. Our response to that is that isn't actually the real issue. It's not so much a question of judicial precedent. The question's a more fundamental one, which is, on the facts as before the Divisional Court, has there been a breach of Articles 7 and 11 of the Charter in respect of the Investigatory Powers Act? And the respondents concede the Charter applies. They concede that there are breaches of the Convention. And what, with respect, is difficult to understand is why the respondents are not conceding breaches of EU law too. And that is the point which the Divisional Court does not address. It's all very well to say, well, none of these decisions are formally binding, and of course decisions of the Strasbourg Court are never formally binding on this court. The actual issue is whether there has in fact been a breach of the Charter, and that's the issue which we say was not addressed. So there's not
and
actually...
you say it's a pretty good clue that there's a breach of the Charter because there's a breach of the Convention. It's not that it's binding, but it's a powerful indication that a separate legal instrument, which would likely be interpreted in the same way, has been breached.
Yes. And we say that's supported by the fact the Court of Justice refers to and also seeks to apply as a minimum standard the Strasbourg Court's case law in the area of surveillance. One sees in La Quadrature du Net citation and reference to the Strasbourg case law.
There's a reference to a similar point, paragraph 125 of the case you've just referred us to.
Yes. Then the final point, which is made by the Divisional Court at paragraph 158, is that the government said it intends to amend the Investigatory Powers Act to remedy what it sees as the defects. And so it wouldn't be appropriate for the court to anticipate what will happen next. Well, the first difficulty with that is that we say that the proposed amendments don't go far enough. That's, of course, a matter the court will consider. But also, no timetable has been put forward for the amendment, and whether to make an amendment is, of course, not a matter for the executive, but ultimately a matter for Parliament. Under EU law, the remedies that are available to the court are, of course, different, and the court may, subject, of course, and we would agree that such a course would be taken, giving an appropriate time to allow any defect to be fixed, disapplying offending legislation.
There's no remedial power under any of the withdrawal agreements or anything else by which the United Kingdom government could amend legislation as it used to be able to do under Section 2 of the European Communities Act 1972.
There are such powers, yes.
So it may not be Parliament then?
Well, it may require the approval of Parliament by affirmative resolution, but not by
that's different from legislation.
But not by primary legislation.
Yep, okay.
And so that's why we say that the findings and the admitted concessions on questions of EU law follow across logically to, on convention law, follow across to EU law. My lords, those are the points which, subject to questions for the court, I was intending to deal with. In terms of the rest of the issues, what myself and Mr. Bunting and Mr. Heaton thought was most sensible is that we deal with the journalism point first, ground one, and then the remaining two convention points last, if that's convenient to the court.
Yes, thank you.
I'm very grateful.
My lady and my lords, the NUJ is grateful for the opportunity to intervene in this appeal. It, like everyone, takes the protection of journalistic materials particularly seriously, and the court has its code of conduct in the authorities bundle at tab 86. The reason why it takes protection of journalistic materials seriously is because freedom of speech itself is important in a democracy as a matter of law. There's considerable agreement already on ground one of the appeal And my lady will have seen that we all agree that the Divisional Court's judgment has been superseded by Big Brother watching the Grand Chamber. The respondents also agree that prior independent authorisation is required under Part 6, Chapter 1, whenever the agencies intend to select confidential journalistic material or such selection is highly probable. And they also agree that the test that should be applied at the independent authorisation stage is the overriding requirement in public interest test. And those concessions in themselves are sufficient to dispose of ground 1, but the NUJ invites the court to go further. And the reason it does so is because those concessions fall into the same area that the Divisional Court fell into, which was to make Big Brother Watch and the limited issues in Big Brother Watch decisive of all of the issues in the Article 10 ground. And the proper approach, we say, is to look at the Strasbourg case law to assess what are the safeguards and then to apply those safeguards to the relevant regimes. And when that task is done, 3 particular points flow from it. The first is that independent prior authorisation is not only limited to bulk interception, it also applies in our submission where there is a likelihood that one of the agencies will obtain journalistic material. That's under all of the regimes in the Act.
And just to be clear, is that part 3, 4, 5, chapters 2 and 3 of 6, and part 7?
And part 5, yes.
Yeah.
The second point that flows from that is that the respondents are wrong to suggest that the safeguards only apply when it's confidential journalistic material that is intended to be selected, or there's a high likelihood of that selection. Our case is that these safeguards apply where journalistic material is likely to be obtained. Essentially, the reason why Strasbourg has said high likelihood is because if you scoop up journalistic material, there is a high likelihood that you will obtain confidential journalistic material. In other words, the problem here is you're confusing the reason why journalistic material is protected with what is actually protected, namely journalistic material, as opposed to confidential journalistic material. And then the third point, which we say follows from the Strasbourg case law, is that the respondents are wrong to narrow the reach of their principles to confidential journalistic material. It also applies to journalistic material in general. It also applies to journalistic material that has been obtained, even if it has been obtained when being created or acquired with the intention of furthering a criminal purpose. And to make those points good, my lady, I'm going to take my submissions in 5 stages. First, by making the point that when Strasbourg first looked at a bulk surveillance regime in Weber and Saravia, it applied the standards as then applied in its general case law. Second, those safeguards have developed since Weber, and they now incorporate a need for prior independent authorisations where the authorities seek access to journalistic material. And that will include, as we will see, an order to identify a source, an order to obtain journalistic material, an order to carry out surveillance on a journalist, an order to obtain access to a journalist's electronic equipment, an order to obtain mobile communications data relating to a journalist. And there are individual cases on each of those points. In each of those situations, the same safeguards apply. The third stage of the submissions is that this is exactly what this court has already found in the case of Miranda. And then the fourth is that Big Brother watching the Grand Chamber has to be understood in that context. And having done those 4 stages, I'll turn to the statutory scheme and I'll make good the point that the relevant regimes don't incorporate the relevant statutory safeguards. My lady, before turning to those points, you asked a question yesterday about the definition of a journalist. And my learned friend Mr. Jaffe took the court to the relevant code of practice where we can see how a journalist is defined in this
He
area.
didn't take it as to it, he just referred to it.
Yes, he gave you the reference. Can I also give you the reference to how the Divisional Court resolved that issue? And that's in Core Bundle, page 961, paragraphs 3, 4, 8 to 9. And the Divisional Court effectively said that those definitions were likely broad enough to cover citizen journalists, to use my lady's words.
Can you give the reference again?
Page 961 of the Core Bundle, paragraphs 348 to 349.
Thank you.
And those conclusions aren't under appeal in this appeal. So the first stage of my submission, my lady, is Weber and Saravia. And the starting point is that at the time the European Court was looking at the bulk surveillance regime in Weber and Saravia, it hadn't yet developed a safeguard of independent authorisation. What it had developed was the safeguard of an overriding requirement in the public interest. And that safeguard came from two cases. The first is the well-known case of Goodwin, which is at tab 27. And in Goodwin's case, Mr. Justice Hoffman, as he then was, had required a journalist to identify a source. That order was upheld by the Court of Appeal in the House of Lords, and the European Court nevertheless found that order to have been disproportionate. It did so, and the reference here is paragraphs 39 and 40.
Which tab, sorry?
My lord, it's tab 27, page 1046.
Sorry.
Sorry, my lord, I'm working from the electronic
Don't
material,
worry,
so I don't
yeah.
have the
Well,
individual.
I'm just in the last entry, but don't worry, I'll get there.
That's fine.
Yep.
And essentially the reasons why the court's judgments domestically were found wanting was because there wasn't an overriding requirement in the public interest. And the court got that test from the importance of journalistic material, see paragraph 39 and 40. And then it applied that test at paragraph 45.
You want us to read this?
Not now, no, my lord. I'm simply giving the references to where this comes from. But it's pretty obvious why we didn't see a need for independent authorisation in Goodwin, because it was itself a case that flowed from a judicial order. The same applies to the next case, which is at tab 30, Ernst in Belgium. And Ernst in Belgium wasn't an order for the identification of a source, as in Goodwin. What it was a search warrant, which permitted journalists' homes and premises to be searched. And the factual background there is at page 1123, paragraph 12. Again, sorry, tab 30, my lord.
Page?
1123.
Thank you.
And the core reasoning is at 1146, paragraphs 91 to 93. Again, we see the emphasis on journalistic material from Goodwin. Again, we see the overriding requirement in public interest test. But what Ernst adds to Goodwin is a second category of material which requires greater protection. In Goodwin, it was a simple order for a search for a source. In Ernst, it was all the journalistic material. And what the European Court observed at paragraph 103 at page 1148 is that kind of category involves a significantly greater impact on the protection of journalistic sources. And so those were the two categories. And what happened in Weber's case, Weber and Saravia is at tab 31, was that the European Court applied the safeguard that had been developed, an overriding requirement in the public interest, but it didn't address independent authorisation because that safeguard hadn't yet come before the court. And indeed, the journalist who was the applicant in Weber and Saravia didn't even argue for an independent authorisation test in Weber and Saravia, and the reference here, my lord, is page 1188, paragraph 142 for the argument. But what, as I've said, the European Court did is it applied the overriding requirement in public interest test at paragraph 149, and it found that that test was met at the stage of examination of bulk material because the disclosure of journalistic sources would be kept to an unavoidable minimum. And this is page 1190, paragraph 152.
Just going to have to slow down a little bit.
I'm so sorry, my lady. I'm conscious of the time, and I'm very conscious of James
I know you, I appreciate that. But
yes, so taking it again to
did
the
you say 1190? Did you say?
1190, paragraph 152 for
Which
the resident.
case are we in there?
Weber and Saravia, my lady.
Weber.
And so what's happening at 1190, paragraph 152, is that the European Court is looking at what happens when you're examining the material that you've obtained through a bulk surveillance warrant.
And this was the federal intelligence services. There's no judicial involvement like the search warrant or
think that's right.
Justice Hoffman's order.
Yes.
So we've now moved into something more analogous to what we've got.
Yes.
Yeah. Okay.
But the point that I'm making is that what's applied is the standard that was.
Yes,
there.
they haven't. But yes, and the thing I'm thinking to myself is there was an oddity there because they didn't need to say judicial authorisation in the first two cases. You were dealing with judges.
Yes.
But this is the services.
Yes. And here it wasn't even argued, my lord.
And it wasn't argued. Yes.
Yes.
But it's all history anyway. Yeah.
And so the simple point that we see from Weber and Saravia is para 152 for when you're examining, paragraph 151 for where you're scooping up, to use the colloquial language. And then we can see after Weber and Saravia the developments, which brings me to my second question. And the two developments that we see post-Weber are number one, a technological development, and number two, a legal development.
And the second one was what?
A legal development in terms of the safeguards. So after Weber, the court recognised that the development of technology means that that type of bulk surveillance regime was significantly more intrusive than first thought. And so it puts this type of regime into the Ernst category. So you're obtaining all of a journalist's material. Secondly, and more importantly in terms of the safeguards, we see the development of independent authorization. And we see that those safeguards apply even when the material has been obtained by a journalist through alleged criminality, and that they apply to all journalistic material, not just confidential journalistic material.
Hold on. So independent authorization, even when acquired through criminality,
Yes,
and all journalistic material, not simply confidential one.
yes.
Actually.
So you protect all journalistic material because if you examine it, you're likely to obtain confidential journalistic material or source material. And so to make that point, those points good, can I just quickly canter through some of these authorities?
Hold on. Yeah.
The first is a case called Tillack and Belgium.
Before we get to that, Big Brother Watch, there's nothing specific in all its many paragraphs about journalists, does it?
Big Brother watching the Grand Chamber?
Yeah.
Yes, it does.
It does,
We
okay.
looked
And you're
at
going
it
to get there,
yesterday
are you?
briefly with Mr. Jaffe, and I'm going to
Right,
finish
okay.
with that.
Yeah.
Yes.
So where did you want us to look at?
Tillack, tab 34.
What is the page?
I've got Visa and Bikos Beteiligungen there. Oh, it's number 35, okay.
Tab 35, I'm sorry.
Yeah, Tilac, don't worry. Tilac.
Can you give me the page number?
1256.
1256, but my lady, it may help if you look at 1260 just to see the what was in issue. Because at paragraph 16, you will see that what happened is a journalist was accused of bribing an official in the European Anti-Fraud Office, and therefore the judicial authorities approved the search of the journalist's home. And so, putting it another way, the journalist had acquired the material through alleged criminality on their own part. And notwithstanding that, looking at the reasoning, at page 1268, paragraph 53, we see the overriding requirement and public interest test being repeated. And then at paragraph 63, page 1270, the overriding...
I'm still on 1260, I'm really sorry.
Very sorry.
You say that it was acquired through bribery and criminality, and we rushed on. Which line on page 126 proves that, or shows that?
1260, my lord, paragraph 16.
Right.
And in the middle of that paragraph, the criminal investigation
Oh,
department...
okay, I've got it now. I can see it there, about 6 lines down, yeah.
So
Thank you.
it was a suspected bribery by the journalist that justified the warrant.
And then you went to 1268.
Yes, 1268, paragraph 53 for the overriding requirement and public interest test. It's the final sentence on paragraph 53. And then that test is applied at page 1270, paragraph 63. And again, one of the points that the European Court makes was to address the alleged criminality point at paragraph 65 on that same page, the right of journalists not to disclose their sources cannot be considered a mere privilege to be granted or taken away, depending on the lawfulness or unlawfulness of their sources, but is part and parcel of the right to information to be treated with the utmost caution.
It's very difficult to try and put this into context. What was wrong? What thing was the breach? Was it too many boxes looked at, or because they went to his home, or what?
It was because my impression from paragraph 63, well, partly it was the extent of the search, which was disproportionate, but also at 63, the European Court was unsatisfied by the real reason for the search.
Well, it was based on vague and
Yeah.
unsubstantiated rumour, which
Yeah.
wasn't good enough.
Yeah. And that therefore there wasn't an overriding requirement in the public interest.
Well, that puts the reference to alleged criminality being irrelevant. It's not part of the, I mean...
Well, it is part of the reasoning, as my lord will say, paragraph 65, because that's where it's addressing that. You don't take away journalistic protection
on the
based
basis
the
of vague
legality,
and substantiated rumours, yes.
but also on the basis of the legality of the source. And this is an important point, my lord, because you may think, as an agency, that the journalist has acquired this through journalistic material, and that may be a relevant issue for the independent authoriser in terms of whether it's proportionate to make the order. But you can't take that away, avoid that protection by just
So is
simply
your
saying-
submission that there is some very broad freestanding principle from paragraph 65, whatever the nature of the violation, whatever the nature of the case, if it is said that the journalistic information is acquired by criminal activity, paragraph 65 says that is not going to be relevant to the assessment of the breach. Is that the submission?
No, the submission is that you don't take away the need to assess proportionality simply on the basis that you assert criminality.
Yeah, that's what I thought I just said.
Sorry, I'm sorry if that's a
I've
different
got
way
it,
of
yeah.
putting it. But it's relevant to proportionality. So it's a safeguard that the independent authoriser has to look at. But what the effect of the definition of journalistic material in the Act does is to remove the protection from that category of material, because it's criminal and therefore the wider protections don't apply to it. It's not just Tillack at 65, it's also all of the other cases. And so the next case is Financial Times, tab 38. And again here, the same type of a mantra at
Page
page
number.
1361, paragraph 63. The source's bad faith was determinative in the domestic proceedings in Financial Times.
What happened here? What went wrong? Who did what to who?
In Financial Times, a source provided material to a journalist based on the material which it had stolen during an audit. But it was asserted that the source was acting in bad faith rather than in criminality, with a view to damaging the market prospects of the company. And so Financial Times is more precisely a bad faith assertion than a criminal assertion. And your Lordship will see at 1362, 65 to 66, Lord Justice Sedley had been particularly influenced by the source's bad faith in granting the order, and Strasbourg found that wasn't good enough.
Oh, this is interview.
Oh, yes.
And so just to address then, pausing here in terms of criminal material. So criminal material, we say, can require the protection of Article 10. And the effect of the definitions at section 264 of the Act is to remove criminal activity at all.
It removes it from the protection of journalists, the protection that otherwise might apply to journalistic material.
Yes. Yes. So the protections only apply under the Act. The only protections only apply under the Act are to confidential journalistic material as defined, which requires you to fall within journalistic material. And journalistic material, you opt out if it's criminal material. And that's the problem. And that's the problem that Strasbourg has found wanting.
From these cases, or from Big Brother Watch?
From these cases.
From these cases, okay, yeah. So we've got to say that these cases apply to the situation generally, yeah.
Yes. And my lord will see that they're being applied here in two different cases.
Yeah.
One a search warrant case, one an order for source identification case. And that's a mantra which we will then see repeated throughout these authorities. I'm not going to give the court all of the relevant pages. And I take the court now to independent authorization and see where it comes from. It comes from a case called Sonoma Utgevers, which is at tab 40. The 1429, my lady, for the head note. And my lady will see at 1429 that this was a Grand Chamber decision intended to give guidance as to the protections. Now, as the head note explains at H3 and H4, my lady, a criminal summons required the provision of photographs that were taken at an illegal street race, which had been held in January 2002. That summons had been approved by an investigating judge, and the judge only had the power to give an advisory ruling on it. And then H5, it was approved thereafter by the regional court. And so, to explain the context in with a little bit more clarity, the police's purpose here wasn't to identify a source; it was to investigate serious criminality. And if my lady looks at page 1346, paragraph 14, the serious criminality was an alleged involvement of a vehicle in a ram raid. And then at paragraphs 27 to 29, on 1438, that ram raid involved the use of a firearm. And what the first safeguard, which is developed, is the safeguard of independent authorization.
Well, hold on. Safeguard for what? What happened? I mean, looking very quickly at 1429, they wanted a photograph of a race which would show a driver. I mean, who gave what information to whom?
So there was effectively a witness summons to require the provision of the photographs of the race to the police. The journalist initially refused to do that. The police agreed that the duty judge that night could give an advisory opinion on it.
Just taking a step back, the journalist had, I think, was allowed to take photographs on the basis that the identity of the individuals wouldn't be revealed.
Yes.
I think that was the starting point.
There was some debate.
Something like
There was some debate about that, my lady, and effectively there wasn't a written confidentiality agreement, and the race had taken place in public. But the European Court worked on the basis that there had assumed a confidentiality agreement. And the reference there is paragraph 64 and 1451.
Right, so the witness summons to get a photograph of a race which would have a driver in it who's suspected of being involved in the subsequent ram raiding with the gun.
Yes.
Right.
And so the safeguard which we draw attention to is independent authorization.
By whom? Before the witness summons?
Yes. And essentially what happened is a group of media organisations submitted a third-party intervention in which they argued for a requirement of judicial authorisation.
Mm-hmm.
And my lord will see that, page 1446, paragraph 45. And that was then approved, page 1455, paragraph 90, as the first and foremost legal safeguard.
I'm very sorry, these references may all be in your skeleton, but at the speed you're going, I just can't even get the references down, let alone look at what you're showing.
I'm sorry, my lord.
I suspect I'm not alone in that from time to time.
So if I can give those references again, my lord.
Will you, 1446 paragraph what?
45.
Thank you.
For the third party intervention.
Yep,
and then the application of that at 1455,
thank you.
paragraph 90.
Thank you.
so paragraph 90 to 92, I would invite the court to read in full, because they set out all of the safeguards. And it's not just independent authorisation, it is independent authorisation of whether there is an overriding requirement in the public interest. So the 2 points together. And this is required as a matter of in accordance with law or prescribed by law. And this was the reason for the breach in Sonoma, see paragraph 100.
Hold on, I'm still in 91.
I'm sorry.
You also have to read 90 to 92.
Yes.
Yeah, so the context was it's no good checking it after you've handed over the photograph. It's too
Yes.
late then, yes, okay. Right, and then the last paragraph you wanted was 101?
100.
100.
I mean, upon the assumption that there's a line of authority that shows what you've just shown us, the real issue is how this maps onto the issues in this case.
Yes.
Where we're looking at in these cases where the court was concerned with very specific applications, which, if successful, would have resulted in the disclosure of source material. The court says that in those cases, these are the principles that should be applied. The question for us is how this maps onto what we have to consider in this case.
Yes, well, can I make 2 points in response to that? The first is that the Grand Chamber is here giving guidance as to what in accordance with law requires under Article 10.2
In this case, where you have a photograph showing somebody that's handed over.
The ultimate, yes, the ultimate conclusion, yes, my lord. But
Not a legislature, it's a court dealing with a case.
Yes, but I'm not trying. The paragraphs 90 to 92 set out what are the first and foremost safeguards in cases concerning the protection of journalistic sources. And those are safeguards which we say apply across the board. And I'm going to turn now after this to show the application and communications data and the application to equipment.
I mean, as I say, it's an open question from me. Just how does this apply here?
Well, we see how it applies in terms of Section 8.4 regime and Big Brother Watch, and I'm turning to that. But the point that the submission which I'm perhaps over-labouring is that in Weber and Saravia, you have the application of the general safeguards. Then you have general safeguards developing in the period after Weber and Saravia. Then you have Big Brother Watch applying those general safeguards. And I just want to show the court how those safeguards come, because simply looking at Big Brother Watch won't give us the full picture. And this helps to understand Big Brother Watch in the correct context. And so the submission which I've just made, that was recognised as a development in the case law, that there was a need for independent authorisation. And the second point is that safeguard applies, to answer my lady's question, not just where the purpose is to identify sources, but to journalistic material in general. And the reason I make that point, my lady, is because the Grand Chamber applied authorities both to information about sources and journalistic information. That's the language used in paragraph 59 on page 1450. And it also was the language used in paragraph 72 on page 1452. The compulsory surrender of journalistic material which contained information capable of identifying journalistic sources. Then we see that word capable being repeated in paragraph 91. And then we see the emphasis on the effect of an order at paragraph 88 could lead to their investigation. And where that comes from is the Council of Europe recommendation that the third party interveners had cited. And it is set out in this judgment at 1444. So my lady will see right at the top of the page. This is the
I've lost which page you are. I was last with you at about paragraph 80 of this case.
yes. I'm still in this case.
Right, and you
going
want
back
page
in this case to page 1444,
1444. Okay, I'm with you now.
where at paragraph 44, the court is setting out recommendation number R, number 7 of the Council of Europe's committee. And in particular, I was bringing the court's attention to the top of page 1444, where we see the definition of source material. Information identifying a source means so far as it's likely to lead to the identification of a source. And going down then to 3 and 4, the unpublished content of the information provided by a source, and the personal data of journalists and their employees related to their professional work. So the European Court was seeking to apply this recommendation in that wider sense to journalistic material. And that's the point that I was seeking to make at the outset, that it's about the effect of an order. Because if you get the unpublished content of information or journalist personal data, then it is likely to identify a source. And that is the problem that Strasbourg is seeking to address in Sonoma.
Yeah.
The European Court then applied the need for judicial or independent authorization to the surveillance of a journalist in a case called Telegraph Media, which is at tab 43. And the specific measure in issue,
Sorry,
Well-
can you give me the electronic page?
1540, paragraph 27, my lady, to see what the measure was.
Thank you.
So, secret surveillance measures approved by the security services involving telephone tapping and observation, presumably by agents. And again, we see here the application of judicial authorization at paragraphs 98 to 102, 1564.
Thank you.
And in particular, at paragraph 98, my lady will see that judicial authorization wasn't the be all and end all. It may just be independent authorization, paragraph 98. And that was the reason why there was a breach, paragraphs 99 to 102.
Well, 97 says the present case is characterised precisely by the targeted surveillance of journalists in order to determine from whence they've obtained their information.
Yes.
Is in principle desirable
Yes.
to entrust it to a judge. That's not a legal requirement, yeah.
And so, to make the points again, my lord, paragraph 98, we see independent authorization. And paragraph 98 also recognises that this is a development from Weber. And paragraph 99 recognises that that development comes from Sonoma, the case that we've just been looking at.
Yeah.
The next case is Nagla.
What went wrong here then? I mean, what
There
was the
an apple-
violation?
The violation was of Article 10 because of a lack of independent authorization.
Lack of prior, because they
These
tapped
were
him and they observed him without getting the judge first, or without getting independent
without getting
authorization
any
first.
first, yeah. So you have the surveillance of journalists, with a view to obtaining journalistic material.
Right, so no prior authorization there in that case, yeah, in targeted surveillance cases, yes.
And
Yep.
the emphasis again on effect of that, because the material, paragraph 86, was likely to lead to the identification of sources. The next case is Nagra and Latvia, tab 46.
1625,
Yes.
yeah.
In this case, paragraph 7 to 9 on 1627, a journalist published material from an anonymous source about flaws in a revenue service database. At paragraph 14, 1629, the police identified the source. And then paragraph 16, that night, 1629, the police nevertheless carried out searches of the journalist's home. Judge was only informed about this the next day.
So what had she said? What was
The journalist published material
yeah,
about flaws in the state revenue service database. It's paragraph 7 to 9 on page 1627, my lord.
so she published information about security flaws, right, in the tax system, yeah.
Yes. The police then identified the source, paragraph 14. Then we have that night searches nevertheless of the journalist's home, paragraph 16. Then only the next day do we have judicial authorization, paragraphs 24 to 25 on page 1631. And the government argued that it wasn't seeking to identify a source, it was seeking to gather evidence in criminal proceedings against the source. That's at page 1649, paragraph 78. But the reason why Article 10 was engaged was because there was a search of the journalist's home on a wide-ranging basis, page paragraph 79. It was the search of all of the material that mattered, paragraph 80. And then at paragraph 81, my lady, that was the application of the Council of Europe recommendation that we looked at in Sanoma. So the purpose of the search wasn't the relevant question. The question was the effect of the search. And the effect of the search was that it was capable of identifying a source, paragraph 82. And essentially, the problem here, to answer a question I anticipate my Lord or Justice Lewis will ask, is what was the problem? The problem is at paragraph 100 to 101, page 1655. There had been judicial authorization, but they hadn't asked themselves the right question, namely whether there was an overriding requirement in the public interest.
So which paragraph was that? I was still reading 82. And after 82, you took us to which paragraph?
100 and 101, page 1655.
So 82, 100. Go on. Yeah.
And the reason I draw my Lord's attention to that is that yesterday there was an interesting discussion with Mr. Jaffe about whether the rules, the code of practice, the IPA needed to spell out the right test that applies. And here you had judicial authorization applying human rights questions, but you didn't have the right question being asked. And that was the reason for the breach. And that explains why overriding requirement in public interest is a quality of law safeguard. It's not just about saying a certain thing in the code of practice, but it's ensuring in substance that the right proportionality exercise is carried out. And that proportionality exercise applies where material is obtained that is capable of identifying a source. The criteria must be sufficiently defined, publicly circumscribed, so as to ensure accountability in practice. The next case that I wanted to draw the court's attention to is at tab 58, and here we have something closer to, in concept, and technological reach to the issues in this case. It's a case called Sedlecka, and the background begins, my lady, at 2412 of the authorities bundle at paragraph 6. So in Sedlecka, what had happened is that a journalist published an article about the National Anti-Corruption Bureau of Ukraine. The source of that article, as my lady will see from paragraph 6, was the head of the bureau, S. And S was investigated for criminality as a result. And the applicant refused to provide information about her meeting with S. As a result, the district court, paragraph 15, granted an order permitting investigators to obtain her mobile communications data. So it's a secondary data case. The purpose wasn't to identify the source who was known. The purpose was to obtain information about the meeting. And in that context, paragraph 54 on 2424.
Well, it's not. It's dates, times, calls, telephone numbers, and the text messages.
Sorry, my lord.
15. It's communications data and communications by the looks of it.
Content.
Yeah, it's content and.
I think it's both. Yes.
Yeah. There's data and
Yes,
content.
it's both. It's both. But the two authorities which were given as key, and I was taking the court now to paragraph 54 on 2424, were Goodwin and Sonoma. Goodwin, of course, for the overriding requirements, Sonoma for the independent authorization.
50.
That's 54, my lord.
Okay. 2425, I call it.
2424, I think, for paragraph 54, and then over to page, yes.
The court reiterates.
Yes. Sorry, my lord, it is 2425. And so those two key authorities are given as Goodwin and Sonoma at the end of 54. And then we see the definition of source material at paragraph 55 as including the factual circumstances of acquiring information from a source and the unpublished content of the information provided by the source. And effectively what we're looking at here is whether something is likely to lead to the identification of a source. That's what paragraph 55 says. And the European Court finds in that context at paragraph 62 that the disclosure can only be justified if it's by an overriding requirement in the public interest. As regards independent or judicial authorization, the reasoning is at paragraphs 59 to 61 at 2426. Essentially, in this case, there had been judicial authorization. The applicant, by chance, found out about what had happened and was therefore able to ensure a judicial consideration of the issue. And so, as a result, this wasn't a prescribed by law case, it was a proportionality case.
So I'm just not with you there. I just looked very quickly at 59 and it appears to be judicial safeguards was an ex parte hearing, so she didn't know about it.
She didn't know about it, but she found out about it, my
She
lord.
found out about it later,
Yes.
and what did she do then?
And what she did then was that she brought it before the court.
Oh, right.
The court expresses concern at paragraph 60 about this, but right at the end of paragraph 60, my lord, it says, given that in this particular case the applicant did in fact learn about
right,
it existed, and the Court of Appeal found it possible to accept her appeal. The crux was about proportionality rather than about prescribed by law.
Well, the crux is the relevance and sufficiency of the reasons provided for
Yes.
authorising the data, yep.
So essentially there a few points just to finish on this case. Paragraph 62 gives us the overriding requirement in public interest case, and then again at the end of paragraph 62 we see that mantra that we first saw in Tillac about criminality, my lady. We see the category that the court puts this into in paragraph 63. Obtaining this kind of material was analogous to the search warrant cases. And so that's communications content and communications data. And then in Sorokin at tab 60, A2540, we see this being applied to the seizure of electronic equipment from a journalist. And again at 2540.
On 2450, what paragraph?
2540, 39 to 50, my lord, is the entire reasoning, sorry. But in particular, the need for independent authorization at paragraphs 44 to 48.
But what was this about? What was being independently authorised? I just don't know yet. Have they seized a photograph? Have they searched his home? Have they got his computer?
They seized his electronic equipment, my lord.
Seized his electronic, like his laptop and his phone?
Yes.
Yeah.
And so, essentially, therefore, where that leaves us before turning to Big Brother Watch, which I'm going to do now, is that you have a clear line of authority.
Mm.
You have orders to provide a source. You have search warrants. You have the surveillance of a journalist. In Telegraph, you have the obtaining of communications content and data. In Zaleska, you have the obtaining of electronic equipment in Sorokin. And in all of those cases, the same safeguards being applied, independent authorization and an overriding requirement in the public interest.
Independent prior authorization.
Yes.
And overriding interest.
Yes. And the same reason being given for the application of those safeguards in all of those cases, namely that what matters is the effect of what you're going to do. And so insofar as the Divisional Court distinguished this line of authority in its judgment at paragraphs 321 to 2, it was essentially because each of these cases arose in a different factual context. And with respect, that wasn't the principal distinction in circumstances in which the effect of the regimes in issue in this case are the same as the effect of the regimes that we've just looked at in the cases in Strasbourg. Can I turn, for example, say you can under a thematic equipment interference warrant.
But there isn't such a thing called thematic equipment warrants, you see. There's part 5.
Yes.
And there's part 6, chapter 2.
Yes.
So I don't like the use of the phrase thematic.
Well,
it's better to say a part 5 warrant which is being used to cover whatever it is that it's being used to cover.
yes. Well, if we use that example under part 5, you have
Yeah.
an equipment interference warrant, which enables obtaining access
Yeah.
to equipment
Of a journalist.
of a category of people, and then you use that warrant to obtain access to a journalist's material. What is the difference in effect?
As you, part 5, you just run through it again a bit more slowly, so I can see that it's the same. So part 5, you're dealing with an equipment interference warrant,
Yes,
which does what again? Just remind me.
enables access to equipment at a thematic level. And so, for example, that could be
There's access to equipment for the groups of people defined in the section.
yes, and you use that to gain access to a large group of people. You then search within that material for journalistic material. And the question which I rhetorically pose is, what is the difference in effect between that and obtaining access to journalistic material through the various means that we've just looked at in Strasbourg cases.
So this is the mapping over point.
Mm.
And I'll come back and deal with that in a little bit more detail at the end of my submissions, but I'm just going to make one point. I'm going to take two further authorities. One is Miranda and one is Big Brother Watch to make those points good. Miranda was my third proposition, my third stage in the argument. And what Miranda finds, we say, is that where the state, through a power, obtains access to journalistic material, independent authorization is required. Miranda is at tab 6, page 219.
Hold on. I can't write the note and look at it. Where the state obtains access to journalistic material, independent authorization required.
Yes.
And then I need to go to which volume or which tab?
Tab 6, my lord.
That's... Yeah. Yeah.
The facts of Miranda may be familiar to the court.
Which is the page reference?
219.
219, my lady. David Miranda, who actually unfortunately died the day before yesterday, I saw on the news, was travelling from Brazil to Germany on behalf of another journalist to collect computer drives containing the encrypted data which had been stolen by Edward Snowden. And the security service requested the police to use a Schedule 7 Terrorism Act power to see whether Mr. Miranda was a terrorist and then to obtain the relevant material. And so, the first point is that this was a case about material which had been stolen. And at first instance, Lord Justice Laws had said that such material requires protection even where it's stolen. And I don't want to take the court to that, but can I give the reference? It's page 107, paragraph 49. And the second point is that the power wasn't a power immediately directed at the journalistic material. It was a Schedule 7 power. And the Court of Appeal found that Schedule 7 power had been lawfully exercised. Paragraph 17 and 58. And then we see at page 250, or page 2, the reasoning in Article 10 beginning at the bottom of page 247, the real issue from our perspective about journalistic material. And the argument...
Hang on, what did actually happen to him? What is he complaining about? Was he complaining about being detained at Heathrow? Or when he was there, did they take the computer drives from him?
Yes, that's the second point.
They took the computer drives from him?
Yes.
Under what power?
Under Schedule 7.
Of the 2000.
Of the Terrorism Act 2000.
Right, okay.
So the purpose of Schedule 7, my lord, to shortcut it, is to assess whether or not someone is a terrorist. That's the statutory power.
Yeah.
They used that power, and as a byproduct of that power, they obtained the material. And Lord Dyson, the Master of the Rolls, found that power had been used for a proper purpose, paragraph 58. But then, when it comes to whether the power had been exercised compatibly with Article 10, that's where we see 247 and the reasoning there. Just
very quickly to guess, page 224, Schedule 75D, is that what the power was?
Does my lord mean paragraph 5 of Schedule 7?
Yes.
Yes.
Well, it's 5 in part, then it's 5D. Give the examining officer on request any document which he has with him. That's what he used to require him to hand over the computer drives, is it?
I believe so, my
Right,
lord.
okay, so I've got the power now. That's the power, yeah. And where do you want us to go next?
To the reasoning under Article 7. Or sorry, the reasoning under Article 10. Which is a 247. And in particular, over the page of 248, the defect that was set out at paragraph 96 by the claimant, which was an absence of authorization by a court or an independent and impartial decision-making body. And Lord Dyson went through the relevant cases First of all, at paragraph 100, the reference to Sonoma, and first and foremost amongst the safeguards, the guarantee of review by a judge, which we looked at it in Sonoma. And then at paragraph 101, Lord Dyson says that it's clear enough that the Strasbourg jurisprudence requires prior or in an urgent case immediate post factum judicial oversight of interferences where journalists are required to reveal their sources. But of course, this wasn't the source case. See paragraph 102, because the source, Edward Snowden, was already known. And so the question that arises, according to Lord Dyson, was whether immediate or prior or immediate post factum judicial authorization is required where journalistic material can be obtained, where the source is known. That was the question of law. He then went through NAGLA in detail, which we've looked at. And having done so, he noted in NAGLA that the availability of judicial review after the event wasn't sufficient. He then looked at Telegraph Media, again at paragraph 110. At paragraph 113, he recognised that there were constraints on the exercise of the Schedule 7 power, but he found that they didn't afford effective protection of journalists' Article 10 rights. The central concern is the disclosure of journalistic material, whether or not it involves the identification of a journalist source, undermines the confidentiality that is inherent in such material and which is necessary to avoid the chilling effect of disclosure and to protect Article 10. It was journalistic material that was confidential in Lord Dyson's view. And then at 115, the conclusion, the 2000 Act contains no adequate legal safeguards relating to what he called journalistic material simpliciter, or to journalistic material, a disclosure of which may identify a confidential source. The reason for that is that paragraph 114 was that there wasn't independent authorization. And so that is again further, we say, binding authority, that where the state seeks to obtain journalistic material simpliciter, to use Lord Dyson's phrase, independent authorization is required. And the Divisional Court distinguished Miranda, again, for reasons which we with respect suggest are unprincipled. Paragraph 314, Core Bundle, page 959. The Divisional Court effectively said that Miranda can be distinguished because it was a case about the compulsory seizure of material, whereas in bulk surveillance regimes, what the material has already been seized, and what matters is the examination.
Which paragraph are you in?
314, my lord.
Okay.
And we say that that's a distinction without a difference. Practical effect is what matters. The effect of the Schedule 7 stop was that the authorities obtained journalistic material. And the effect of the bulk interception powers is that the authorities obtain and then examine significant quantities of journalistic material.
Sorry, that needs to be broken down. What actually happened in Miranda was that material was handed over,
Yes.
and the person at the airport got the computer discs which had the material
Yes.
on. So, translating that to 314 now, am I correct in understanding you, or have I just made a mistake in listening to you, that you're saying that the acquisition under, for example, Part 6, Chapter 3, or Part 5, the acquisition of the information, irrespective of the next stage, what, if any, safeguards exist in relation to somebody looking in the data that's been acquired, that the acquisition of data, the collection, if you like, needs prior independent authorisation.
That's not my argument.
That's not that. Then that's what I was worried about. So what is your argument?
The
then?
NUJ is concerned by that as a matter of policy, but as a matter of law, their argument is that the proper analogy is to when the state actively examines or searches for the journalistic material within the material that has been obtained.
Right. So you say Miranda and the case that you've applied or referred to apply when there's
When the
an
effect...
yes. But what does that mean in this case? Are you going to take us to the act? It
Yes.
would help me more if you said when they exercise section 15296A, that's where it applies. But have a go again, just so because I'd misunderstood and I mustn't misunderstand it.
So say it's Art 6, Chapter 1.
Yeah.
The state obtains a significant quantity of material. It has everyone's material, journalistic and non-journalistic.
Yeah.
The state has it.
Yeah.
The state isn't actively examining it until the next stage.
Exactly. And is the collection of data one that's covered by Miranda?
No,
Right.
what we say is that what Miranda covers is where the effect of the power is that you're obtaining the information, you're actually looking at it. So you have the information, but you're not looking at it. When you then go to look at it under the bulk power, the effect is that you're examining.
So it's the examination is what attracts the Miranda and European Court line of cases.
Yes.
It's the examination of data, right? Okay.
Yes. And so that's that's Miranda in effect. And Big Brother Watch makes effectively the same point. The first point in Big Brother Watch, of course, is that the government argued in Big Brother Watch that the line of authority that I've set out didn't apply. And the page here, my lady, is 2320. And so the government expressly sought to distinguish Sonoma, Telegraph Media, and it said that a requirement of prior judicial authorisation would make no sense in the context of bulk interception.
I'm sorry, what page are you on? What paragraph?
Paragraph 433 on page 2320, my lord.
Yes.
And so halfway through, my lord, we'll see the references to Sonoma and Telegraph,
Yes.
and then the submission which was made that it wouldn't make any sense in bulk interception context.
And they lost that,
Yes.
and they've conceded that. So that's
Well, can I first? I'm sorry, my lord, to take this so slowly and to go over ground perhaps unnecessarily. But I want to look at the way in which they lost it, so that we can understand whether the concession is right. or whether
right.
the concession
Okay,
goes
that's
far
where you're
enough.
going then, right? Okay.
Yes. And so what we see is Mr. Jaffe showed us yesterday at page 2323, paragraph 447, the Sonoma safeguards being repeated and applied. And but these paragraphs do again require some study. So that where it begins at paragraph 448 is where the intention is to access confidential journalistic material, for example through the deliberate use of a strong selector connected to a journalist, or where as a result of the choice of such strong selectors there is a high probability that such material will be selected for examination. The interference will only be commensurate, and it goes on to explain the safeguards. So that's regardless of whether or not the intention is to identify a source. What matters is whether it's very likely.
Highly probable.
Yes. The reason why it's very probable or highly likely is because you're obtaining the material and you're searching through it.
Yeah.
As my lord sees, it applies here, Ruman and Schmidt, which is another search warrant case. So that's the category of material that you're in. And therefore we see at the end of that before the intelligence service used selectors or search terms known to be connected to a journalist, or which would make the selection highly probable, then you need independent authorization.
And they've conceded that.
Well, they haven't. They've conceded it in a very specific way, which I'm going to come to. And what the independent authorizer needs to do is, of course, to apply that overriding requirement in public interest test. And we see that in the following paragraphs. So it's not just where the intention, it's where you're applying selectors which are known to be connected to a journalist.
Mm-hmm.
It also is where you have obtained it and it becomes apparent that you've obtained it. And this is paragraph 450. In that context, the same safeguards apply. And the reason why 456...
Hold on. Do we need to read 450 or not? Because I just started reading it.
Yes, my lord.
Right, okay.
Well, the use of the phrase confidential material, what does that refer to precisely? Is that all journalistic material or just confidential journalistic material?
The way I understand it, my lady, is that what the European Court is saying is that when you're searching for material connected to a journalist, so that's the use of strong safeguards, what is highly likely is that you will obtain not just the journalistic material, but also confidential journalistic material. And so it's an emphasis on the result.
Well, it's actually the use of selectors or search terms connected to a journalist.
Yes.
You translate that into, the reason why that's a problem is because the effect, as you call it, and then you create what I'll mislabel an effect principle.
Yes.
But following it through, there's a series of things. 448 seems to be saying where it's intended to go after the journalist, there's a high probability that there is interference either of a sufficient gravity to be measured as if you were interfering with the home or whatever, or workplace.
Exactly, yes.
That's what it says. And then it says what it says about the need to have overriding interest, public interest. Then it goes on to say it's different when you don't know at the outset what's going to happen, and it deals with that.
Par 450, yes.
Yes.
Indeed. And again, there it's about a journalistic communication or related communications data in paragraph 450.
So what do we get from 450? Just remind me.
What we get from 450 is that where you realise that you've obtained that material, then the same safeguards apply.
So could you repeat that?
I'll use the language in the paragraph. So even if a journalistic, it's at the bottom of page 2324, even if a journalistic communication or related communications data have not been selected for examination through the deliberate use of a selector, and it then becomes apparent that the communication or related communications data contain confidential journalistic material, their continued storage and examination should only be possible if authorised by a judge or other independent and impartial decision-making body invested with the power.
So we've achieved a level of specificity whereby the person holding the data realises it is now apparent
yes, it becomes
that they hold confidential journalistic material.
Yes. So the
At
first
that point, they should go for judicial authorisation.
also yes, the first is where you're seeking, or that's likely that you
Yes, if you set out with a purpose, you say you've got to get prior judicial authorisation. If you haven't set out with that purpose, but there comes a point where you become aware that you have confidential journalistic information, that material, then at that point you should go for judicial authorisation.
yes.
For continued storage and examination, it's already too late to get independent authorization before you collected it.
Yes.
So then it's continued storage. You either have to delete it or you have to go to an independent whatever and get them to authorize continued storage and continued examination.
Yes, exactly. So that's the point, my lord, to see whether or not you can continue to examine it.
Yeah.
And I don't ask the court to read it now, but then those are applied at 456 and 457 in effectively the same terms. Those equivalent safeguards are then also applied in a different regime in Big Brother Watch, the Chapter 2 regime. And that regime is broadly analogous to Parts 3 and 4 of the Investigatory Powers Act.
That's not content, of course, that's communications data, isn't it? The what, where and when. A phone attributed to number 1, 2 and 3 uses a mast just outside Lincoln at 4 o'clock on a Wednesday afternoon. It's that data, isn't it?
Yes.
Not content, not...
Yes.
Yeah, okay.
And the Grand Chamber's findings on that are at 2340.
Yeah.
They begin at 524 to 525.
Where am I looking at?
Sorry, first of all, it's at the, sorry, it's 2339,
Yeah.
paragraph 524. And this is going back to the original first section's judgment. And this is the Grand Chamber summarising why there had been a breach of Article 10 below.
Mr. Bunting, I'm conscious that there's been an agreement in relation to the use of time.
Yes.
I know this is difficult, and I did think we were trying to squash a court into a pint pot in some respects in this hearing, but certainly it would help me a few minutes before we rise, if you start trying to encapsulate how you say this all applies to the issues we have to determine in this case. In other words,
Yes.
you've shown us the path. The question is, where do we get to at the end of it?
Yes. Well,
And that's what I'd really like you to.
can I do that then,
if
my
you
lady?
could, yes.
If I can just make the point that first of all, my lady will see the reasons at 524 to 525 why the first section had found a breach in that context.
Yes.
And the Grand Chamber effectively applies those. So you had there prior judicial authority through
Yes.
case, and you had the overriding requirement in the public interest. And so what that shows is that in those two contexts, Big Brother Watch approves those safeguards. And that allows me to then address before lunch the reasons why the statutory regime is incompatible with Article 10. And so the 3 points which I make before addressing the regimes in particular are: number one, those safeguards apply where the effect of a power is to obtain or examine journalistic material. And Mr. Jaffe has made this point yesterday, which is that the concession only applies to one of the regimes and not to the others. Second problem is that the definition of confidential journalistic material is too narrow. And I've made that point as I've gone through the submissions. And the third problem is that even when the statute now will recognise, we hope, independent authorisation in Part 6, Chapter 1, there is still not going to be a formal requirement that the independent authoriser applies the overriding requirement in public interest test.
He's got to, because otherwise it's not going to be necessary and proportionate, which
Yes.
is the legal test.
And we agree with that. And if this court were to find that, then that may be the end of it. Because then the law would be sufficiently clear and publicly accessible. But
So that's likely said to be a narrow area of
Yeah.
dispute.
yeah,
The respondents say it's already in there, and you say it needs to be. Those words need to be
Made
included
express.
expressly. That's the
So those
nature of the issue.
those are the three introductory points, and then
Yes.
turning then to Part 6, Chapter 1 and Chapter 3, what they permit the security service and intelligence agencies to obtain is the contents of communications information and related secondary data. And the safeguards that are currently in place are insufficient. The respondents concede that. And so, as matters currently stand, and until the remedial order comes into effect, there is an ongoing breach of Article 10. And that is because there is no requirement either for independent authorisation or for an overriding requirement in the public interest. The remedial order will address some of this in part, but it will not stop the point that my Lord Justice Lewis has just put to me, namely where the agencies become aware of information and they intend to continue to analyse the information. And so turning to the remedial order, which my lady will find supplemental bundle, page 213. It will become law at some stage in the future. Effectively, what this is the first stage of a consultation. But it still is too narrow in that it only applies where it is intentionally obtaining confidential journalistic material, or that is highly likely. And you've heard my submission about the effect and the case law on that. Part 6, Chapter 2 permits the bulk acquisition and examination of communications data. And here there isn't really any protection at all. In particular, if the state obtains communications data under a bulk acquisition warrant and then seeks to search within that for source material, there is no statutory protection to prevent that from happening. And it's not just that these powers, we say, can technologically be used for this. The respondents know that they are used for this because they address this in the various codes of practice. And so if I could just quickly turn up the
Was that chapter 2 of part 6 you said?
Yes.
Right, okay.
So here, bulk acquisition communications code, tab 80, page 3944.
I think you're just going to have to wrap it up quite smartly.
I am going to, I'm almost there, my lady. I will be finished by lunch.
Yes.
And
We'll
so,
have to think about what we do with Mr. Heaton's submissions
yes.
before then as well. Yes.
Yes, I've craved his indulgence already. Paragraph 6.28 that shows that where an officer decides themselves to examine communications data specifically to determine a source, all they have to do is get that approved by the director within the organisation. And that's obviously deficient. We say that the independent authorisation test applies. And part 7 has the same problem. And again, the code of practice in part 7 recognises that journalistic source material can be sought. See the code of practice, tab 79, page 3896, paragraph 7.45. Again, 7.45. So where the intention is to select for examination any data in order to identify a source of journalistic information, the approval of a person holding the rank of director or above within the organisation should be obtained. Again, no independent authorisation, even when you're expressly looking for that material. Same problem with confidential journalistic material, 7.46. Part 5, my lady, permits thematic equipment, permits equipment interference, and that can be equipment interference at a thematic level, as Mr. Jaffe has explained. And even again there, once the warrant is approved, there are no examination safeguards applicable to the search and examination process of what is obtained. And that's the result of the agreed position before the Divisional Court. And if I can give the reference here, it's Core Bundle 984, paragraph 73C. So no requirement for independent authorisation, no application of an overriding requirement in public interest test.
Could you give us that reference once more? Core bundle.
Core Bundle 984, 73C.
Thank you.
And then in part 3, the problem here, my lords and my lady, is that section 77 requires an overriding requirement, but only where it's where the purpose is to identify or confirm a source. So there is no requirement for an overriding requirement in the public interest where journalistic material is likely or highly likely. And there is no requirement to stop and get authorization if journalistic material is actually obtained. And so for those reasons, the NEJ endorsed the annex, which is to set out the Liberty Skeleton argument at page 79 to 82 of the core bundle, and we respectfully invite the court to find a breach of Article 10. Can I assist the court any further? I'm sorry for taking so much time.
No, thank you very much. Mr. Jaffe, Sir James, we're running into a slight time problem because, as I've said already, there's a lot to get through, and clearly the respondents have a lot to answer, not merely from your side, but also in the submissions of Mr. Bunting. So, can I leave you over the lunchtime adjournment to discuss how you're going to manage this? Because the time is short, and time should be divided fairly between the two sides, putting Mr. Bunting on your side of the...
No, that's perfectly fair enough. Just as a provisional suggestion, I know Mr. Heaton is intending to be pretty short on both of these issues, certainly no longer than 10 minutes on each of them, so 20 minutes in total. But could I ask the court, if the court have a few minutes over the short adjournment, to look at paragraphs 44 to 55 of our skeleton, which summarises the arguments on those two issues, those 11 paragraphs.
Now, the other thing to mention is that tomorrow is a strike day. I don't know whether anybody's going to be in any difficulties, because otherwise I would have suggested we sit early. So I'm seeing some rather gloomy expressions. Is that not going to be possible?
I'm afraid Sir James won't be able to do that. Right. What I will do is I will consider with Mr. Heaton over lunchtime just how briefly we can deal with the points, whilst giving the court the opportunity to ask any questions. I hope that's
and the skeleton from paragraph 44 to
55.
55. Okay, thanks.
I'll rise now so we can have 2 o'clock.
All right.